the state office. And so, yeah, yes, your data is out there, and it's beyond Wasatch District, and your child is being tracked. So, I mean, that's a given. We're required to know who's learning, who's not. We can only do that with data. That data goes to Salt Lake. They aggregate it and bring it back to us. There's a lot of testing banks out there. The one that comes to mind most that I have to think is the biggest one is the one that's located at the College Board. That's your student data, but it's not located at Wasatch School District. It's got your students' ACT scores, SAT scores if they took those to get into college, any AP exams that they took, any other test that they took to see if they were ready to take the ACT test. There's a plethora of tests that the College Board provides. And I know that they have a testing bank because I've had students who came back and said, you know, I can't find my little certificate from AP scores, and we've called College Board and they provided them with a new one. So they've got that information. That's a given. So I think it's a little bit disingenuous to think that that you can stop your child from being tracked. And I don't want to be flippant, but your child is born, they're assigned a Social Security number by the federal government, and they track us for life. And so I kind of was taken back by that statement. And every year we give them more information about us, even how we spend our money. Then I went on down this, and it said, this revision allowed additional ways for your child's personally identifiable information to be released without prior parental consent. Now, I know that I went over this, and I'm sorry if I'm redundant, but I really feel strongly that we need to look at that again, because as I said last month, it really didn't, and it doesn't. So if you put up the old policy, Jill, I would appreciate that. The part in question is, on the new policy is 9, but on the old policy, if you read number 8, it states, what have I got? I've got 2 new ones. Anyway, the old one, it says, allowed to be reported or disclosed pursuant to state statute with additional protections for further disclosure. Now, as I was reviewing that, that's almost an incomplete sentence. And so, we revised it. And on the new policy, if you put that up, because I added to parents of dependent students, then number 8 dropped to number 9. And now it said, allowed to be reported or disclosed pursuant to state statute with additional protections for further disclosure. And to complete that sentence, I defined who those ones could be defined to. But with or without that defining information, that stood. I mean, it was there. You didn't know where it was going, and so to be transparent, we added it, but it was already there, so it didn't really change where this information was going. It didn't add anybody to the list, and so I found that a little bit troublesome also. Then it went on to say what our policy should say, and then and I was troubled by that also, because it is so restrictive that it would stop us doing business in a lot of forms, and it has its own legal issues. But what I really saw there was, and maybe I'm misled, but in talking to some of concerned people, they said, well, we want to make a statement to the federal government that we are not going to do this. And I don't know if that's the way everybody felt, but it kind of put us in conflict with the statute, which we are a law-abiding organization, and we cannot be in conflict with the statute. Then at the bottom, it asks for some definitions, and if you'll bear with me, personally identifiable information, what is that? anything that identifies your student, birthday, day, parents, phone number, all of those things, test scores, all of those things that identify your student are identifiable information. Now, some of that is given as directory information, and those of you with the students in the school have received a letter from us saying that we would like permission to use your students' directory information, and we've given you a list of that. And it's really an opt-out rather than an opt-in, and we have had kids opt out. But what we use that directory information for is things to allow us to put your child's picture in the yearbook, put their name on a play bill, to put it on a sports roster, all of those things that, and you can say no, and we won't do that. Your child doesn't have to be identified as on a member of a sports team. They don't have to be in the yearbook. If we take a picture of the class, we can make sure your student isn't in the picture. All of those things are doable under that personally identifiable information. Authorized representative, when we have somebody that comes and does an audit, that governing body, whoever is going to do the audit, for instance, if we got audited on Title III funds, mostly that would come from a Department of Civil Rights, and whoever this Office of Civil Rights authorized to do that audit, they would come, and that's who that would be. Then you asked me for the definition of biometric data. I'm not sure. Maybe Mr. Robson can help me out here with what all is included in that. But the statute is really clear. It says if you gather this kind of data, then you fall under a different level of protection. And there are more protection guidelines to deal with if you collect this data. I cannot, right off the top of my head, think of many times we've collected that data, but I did opt on my computer to have my password, my thumbprint. Now that might be considered biometric data, and so I hope Carl's taking good care of that thumbprint. But I can't think, we haven't done that for students yet, and so I really can't come up with any that we've collected so far. But that's not to say that we wouldn't. Maybe the technology would be such that they could be voice activated and the kids could access their accounts through their voice. Whatever, those things. But if you do go there, then there's a whole other level of protections that fall into that. Studies on behalf of schools. These are things that are optional. Schools can do these, or they don't have to do these. These are the things that keep us on the cutting edge of research. And we have participated with universities in research. We've been involved in a research project with BYU on the positive effects of PLCs. These are things that keep our teachers involved in the latest techniques of teaching. It keeps us knowing how our students are performing and keeps us on the cutting edge. And we can only do those with additional protections, and that's the last one on your list. And additional protections could be, really is dependent on what it is, but generally it covers things like, why do you need it? Are you a viable educational purpose person? It has to be a viable educational purpose, and it has to have the way you're going to use this data. How is your data going to be published? How you're going to get rid of the data once you're finished with it. All of those things have to be agreed upon before they can have those informations. So that's just to clarify what there was in this statement, this flyer. And I think that that's important because many of the comments we got centered around the information on this flyer. And I felt like that it was a little bit misleading because many of the comments that we got sound like, we understand you're illegally providing our child's information to other organizations. FERPA protects our students, don't change it. It is clear, these comments that they made, why are you putting my child's data at risk? And it made me think that the bigger problem that we've got now is really damage control, because I really believe that the people in our community, after having this period, believe that Wasatch School District is loose with their student data, which could not be further from the truth. We are not loose with your students' data. This law is to protect your student data, and I really believe, that when we get these comments that say, why are you dispersing and why are you making it so easy? You're going to give this to anybody who wants it, and that is just not factual. And that's why I say it's really kind of been sensationalized or dramatized or something, because it just has morphed into something that it was not. And so as I got all this information, and I looked at it, and I thought, okay, damage control, what do? We revised the policy. And I think the revision does two things. Jill, would you put that?
One second before you move on. Will you explain why you added number 7? That is what you actually added to the policy when you brought it back, and there was a reason that you added it.
Yes, there is a reason. Number 7 is the one that we at the district office deal with the most. And you wouldn't think so, because you would think it was a given that parents have the right to get their students' information. Unfortunately, divorce is not uncommon, and what we get is the custodial parent coming in and saying, I have custody of these kids and my ex is not going to get any data. They cannot have this data, they do not have anything. And that isn't law. Both parents are parents, and both parents, unless there is a court order saying that the ex can't have the data, they get it. And so I put it there to make sure that people understood that, because that is the one that we deal with most often.
And Vicki, just one more thing on number 3 that we just had, a couple of words were added, if you'll just explain.
The authorized representative was added, and it was more clarifying than anything. Yeah.
So it was the
doesn't
same,
change.
it was the
Right.
same before. We still had the federal.
No,
We still had the education agency.
We still had the audits in the education agency, and
You had the federal education agency.
right, and there was, but
That is state and local.
We have education programs or educational for authorized representative.
right, but it's been in the
This is
statute.
clarifying to,
So,
okay. Go ahead to the revision you're proposing.
okay. Very short, and the reason it is so short is that I decided that the other one had too many words that raised too many concerns and that people were afraid of, and that I couldn't deal with. And so, we need people to know that we are law-abiding citizens and that we are going to protect their student data. So it's very short. I'll read it for those who can't see it. It is the policy of Wasatch County School District to comply with the laws of Utah and the United States in storing, maintaining, and releasing student date records. That is what we do. And number 2, each year district administrators will provide training to employees regarding protecting student personal information and records in compliance with the law. And we do that now too, but that is required by law that we do that training, and obviously we do. So it's to the point, it's short. I think it takes away the grief. It also, to me, I do know that some people, I think there is an element out there that wants us to stand up against the federal intrusion. We've all heard that. But that is not the school board's role, in my opinion, and you may have a differing opinion. Our role is to provide the protection under this policy to our students. And so that is my report after I've looked at all of the comments.
Okay. I'd like to ask Mr. Robson to come up and talk to us about his recommendations here and what his thoughts are legally on this issue. Thank you, Mrs. Gatmeyer, for your presentation.
Let me give a little perspective, if I may, about FERPA. FERPA was first passed, and FERPA, as we all know, is the acronym for Family, Educational Rights, and Privacy Law. And we give all staff